All right, so we'll go ahead. We talked a lot about legislation, a lot about where things are going. We'll twist to kind of the here and now. So the way I usually start off with our guests is so dad walks into your office and says, "What's going to happen to me?" Um, what's the process look like? What do you tell that dad in that first meeting?
It depends. I serve kind of three counties where I am. And so, part of it depends on what county we're in. For instance, if you're in Galveston County, I'm going to tell you, look, we file this petition. We'll ask for equal possession time, or in the alternative, the standard possession order. And we go in there on temporary orders is the first thing that happens. And I tell them, look, there's in Galveston County, there's three courts that handle family law issues, and they all share one associate judge. And you got to go through the associate judge before you get to the presiding judge. And I tell them, look, when we go to that associate judge, no matter what we say or what evidence we put on, he's going to order you to pay child support. He's going to give you the minimum amount of possession time the law can allow. He's going to give mom the exclusive right to make educational decisions, and then from there we can appeal that basically to the district court. But I tell you, right off the bat, you're going to lose with this judge, and it depends on what county you're in, but generally it's we'll serve your ex, and then we'll either do mediation or temporary orders. Um, and then after that, if we don't come to terms, we'll do discovery for a few months, and we'll do mediation again. Go in there for a final trial. Texas is unique because you can actually have jury trials in family law issues. So I tell the clients, look, if we go in front of the judge on temporary orders and you lose, I mean, after that, if you don't find out anything tremendous in discovery, you probably either want to settle because you don't want to have this judge hear your case again. You already know what they think about it,
Yeah.
or you ask for a jury trial, which obviously is going to be a lot more expensive. But uh, that's kind of your options. And in Texas, I don't think it's too different from many other states. You hope they agree along the way, and if they don't, your chances aren't too good in front of the judge. You know?
Yeah, see, this is what's scary. So California is, we talked a little bit before, it can be a crapshoot because mediation is mandatory. And in some counties, those mediators make recommendations. So you end up with a young social worker making a recommendation on custody and visitation. And we don't do necessarily temporary orders. Like you're going to file, you're going to go to mediation, and 2 or 3 months down the road, you're going to be in front of the judge. And the mediators are wildly inconsistent. The judges have broad discretion. Some judges rubber stamp the mediation reports, even though there's really nothing behind them other than just an uneducated opinion. And other judges are just absolute wild cards. I will say, I've been practicing for almost an entire year now. I've seen a dramatic shift in judges being willing. We get the mediation report back, and it's close to 50-50, or it's a 40-60 split of leaning towards the side of we need to maximize the time with each parent. That's one thing I'm hopeful about. I had a judge the other day who looked at mom and said, I'm in the business of making sure kids spend as much time as possible with both parents. So we're moving in the right direction, but I'd be curious to have your opinion on this. So California, it's kind of the Wild West. The judge can really do whatever they want. Where Texas, you have the standard possession order. In your opinion, is limiting the judicial discretion, because this is a topic that comes up, is that a positive or is that a negative for non-custodial parents?
I mean, it depends on, I think it's a positive to limit the discretion, uh, as long as, the presumption is for equal possession, right? And
Yeah.
then limit their discretion. I mean, it goes back to, right now the starting point is the standard, or, the expanded standard possession order, and then a judge can make adjustments as necessary. Well, we want to start off at 50-50, and then the judge can deviate from there as necessary, you know? So, I mean, that's one of the things our opponents harp on is, oh, our, 50-50 schedules are going to tie the judge's hands and it's going to limit the discretion. And I mean, right now, everybody knows there's a rebuttable presumption for the standard possession order. So, I mean, I didn't know California was like that. And, but for me, at least in Texas, it's like the judge's hands are always going to be tied because you're always going to give the judge some direction. We don't want the Wild West. You got to have some predictability.
Guidelines.
Yeah, guidelines.
Guidelines in Texas. That's the thing. I think there's zero consistency. And at least if you have those guardrails, you have some level of consistency and you can adapt and adjust to that. California, you have no idea.
The Texas, one thing is this Texas standard possession order, the family law attorneys and the legislature, they're very proud of that order because it is extremely detailed. I mean, you can say, all right, we're going to put in the standard possession order. And you know what? I mean, your whole possession order down to the hour, just from the standard possession order. And so, yeah, it's good to have guidelines, but I mean, all over Texas, you mentioned the judge rubber stamping the mediation reports. And the most common thing in Texas is judges rubber stamping that standard possession order. Everyone gets a standard possession order. They'll deviate and give the non-custodial parent less time if there's, abuse or neglect or something like that. But they rarely deviate the other way and give the non-custodial parent more time, so it sounds like California and Texas are maybe at two opposite ends of the extreme,
Yeah.